Welcome back to the channel, everybody. Thank you so much for joining me and allowing me to continue to be your daily advocate. If you're new here or you're not subscribed for any reason, please do me a huge favor and hit the subscribe button. Thank you to all of you who have been watching and following me for so long. It truly means a lot, and I'm glad that I can be this person.
In response to rumors that a settlement in the Ripple SEC lawsuit is imminent, crypto law founder John Deaton says he does not believe one will be reached within the next 30 days. Given recent positive developments, the Ripple SEC case appears to be steadily progressing. SEC staff are losing faith in the agency's ability to win the case, according to a recent tweet by Fox journalist Eleanor Terrett. According to a source close to the SEC, Commissioner Hester Crypto Mom Pierce expressed private concerns that the SEC might not achieve the desired result. As previously reported by You Today, Ripple CEO Brad Garlinghouse stated that the court would make a decision. The Securities and Exchange Commission's pending motion to strike Ripple's fair notice defense has yet to be decided by the court. Ripple and the XRP community are also waiting for Magistrate Judge Sarah Nepern's decision on the SEC's motion for reconsideration, which John Deaton has dubbed the largest decision in the case. Judge Analisa Torres has yet to rule on the motions to dismiss filed by the individual defendants, Brad Garlinghouse and Ripple co-founder Chris Larsen. According to John Deaton, if the individual defendants' requests to dismiss the complaint are denied, Ripple may pursue additional discovery. Attorney Jeremy Hogan has predicted when the Ripple SEC lawsuit will be resolved in recent tweets. Ripple expects the lawsuit to end between August 26th and November 18th, according to Hogan. He went on to say that the case could be resolved at any time, implying that no agreement had been reached. In early March, an XRP-friendly lawyer published a document outlining a few rules that the SEC and Ripple could follow, including a face-to-face or video conferencing meeting to negotiate a settlement within 14 days of fact discovery. Hogan also predicted that the settlement talks would take place in April or May. He stated that the most recent settlement discussion, which took place a few months ago, was unsuccessful, and that mediation would be the most likely next step. In September, Hogan predicts a summary judgment hearing. Guys, this week I came upon a very interesting website. See the link in the description below. It's called Stable Pool, and everyone who registers on their website until October 31st will receive up to $50 in crypto. It's a new platform, but during the first week, they received more than $80 million of investments. They also have a partnership with a Japanese exchange called TaoTaoX.com. When you go to their website, you can immediately claim the free $50. After that, you go to Top Up on the left side of the screen. Then at the right, you select a currency and enter the amount you want to deposit. After that, you are free to go and earn money. Note, I'm not a financial advisor, and investing is always at your own risk. In addition, worth noting are two recent orders issued by Judge Analisa Torres in the Ripple vs. SEC case. One of these pieces of news is great for Ripple, but it's not so great for Chris Larsen and Brad Garlinghouse. Judge Analisa Torres denied the SEC's petition to dismiss Ripple's fair notice argument. Judge Analisa Torres also dismissed the SEC's motion to dismiss Chris Larsen and Brad Garlinghouse's complaint. The court denied the motion of the individual defendants because it assumed that the SEC had established that a violation of the Securities Exchange Act had occurred. Despite this, the SEC must show that the individual defendants entered the particular endeavor and participated in its success, and that their activities contributed to its success. According to the court, the SEC must also demonstrate a broad understanding of their overall position in Ripple's illegal sale of XRP. It's worth noting that the SEC does not have to show that the individual defendants were aware that the Ripple scheme was illegal. Rather, the SEC must show that the individual defendants were aware of or recklessly ignored the facts that made the Ripple scheme illegal. The court's presiding judge considered both parties' arguments and concluded that the Twombly plausibility standard applies to determining the sufficiency of all pleadings, including the pleading of an affirmative defense, adding that courts apply a lower plausibility threshold when evaluating motions to strike affirmative defenses. Judge Analisa Torres, in rejecting the Securities and Exchange Commission's request, also stated that Ripple is entitled to a full opportunity to plead and have its fair notice argument adjudicated before a plaintiff can impose responsibility. The company lacked, and the Securities and Exchange Commission failed to give fair notice that its behavior was illegal, according to Ripple's fair notice argument. The commission tried to dismiss this argument, claiming that it was legally deficient and that it would force Ripple to engage in intrusive discovery. Many of the documents claimed to be privileged by the SEC should also be included in the regulator's intrusive discovery. The lawsuit over DPP is still ongoing, as the plaintiff has asked the court to reconsider her previous decision. Ripple was granted access to some documents by Judge Sarah Netburn, including notes and emails about ex-Commissioner William Hinman's 2018 Ether speech. The SEC spent a lot of time claiming that the speech was his personal opinion, but when the court ruled that the records used to prepare for the speech were not covered by deliberative process privilege, it backfired. What do you think? How do you think Ripple will use the fair notice to their advantage? Furthermore, Magistrate Annalisa Torres also denied Chris Larson and Brad Garlinghouse's request to dismiss the SEC Commission lawsuit against them. Brad Garlinghouse's claim that XRP sales were predominantly foreign was rejected by her decision. The presence of a domestic securities transaction is a necessary but not sufficient predicate for invocation of U.S. securities law, according to the Second Circuit, she explained. The Second Circuit has also found securities law violations to be predominantly foreign and thus outside the territorial scope of U.S. securities law when transactions involve wholly foreign activity clearly subject to regulation by foreign authorities. The conduct occurred in a foreign country and concerned securities in a foreign company that were traded entirely on foreign exchanges, in the two cases where the Second Circuit determined that violations were primarily foreign. As a result, Garlinghouse and Chris Larson had to prove that the sale of XRP was legal in the United States. They were, however, unable to do so. The case will not be dismissed as a result of Judge Torres's decision that it falls under the purview of U.S. national security legislation. Here, the court finds that the individual defendants' offers and sales were not predominantly foreign, the judge said. These offers and sales were made by U.S. residents, involved alleged securities issued by a U.S. company, involved at least some offers and sales made on U.S.-based platforms, and included at least some offers and sales to U.S. buyers. As a result, applying Section 5 to these offers and sales would increase confidence in the United States securities markets and protect U.S. investors. While Chris Larson and Brad Garlinghouse both lost their motions, Ripple came out on top. It's unfortunate, but will Brad Garlinghouse and Chris Larson benefit if Ripple is released from this lawsuit? What are your thoughts? Tell us in the comments section. Also, a big shout out to Jeremy Hogan, who appears to know what will happen in the case. As he put it on Twitter, "Dear Judge Torres, I understand you've been busy this week working on the pending rulings in the Ripple vs. SEC case. We'd like to get those rulings today, if possible, on behalf of myself and a few other interested parties." And this was on the morning of Judge Torres's order. He appears to know what will happen in the case. And like this order, his prediction that the case would end in November may turn out to be correct. After Judge Torres issued the order, he sarcastically showed it to her. "Dear Judge Torres, I am writing to express my heartfelt gratitude for all you have done. Thank you for your prompt response. It is greatly appreciated. Enjoy your weekend and stay warm." Jeremy Hogan, on the other hand, has warned that the price of XRP will fall as a result of the second order against Brad Garlinghouse and Larson. "Ripple has taken aim at my favorite issue in the case, whether anything Ripple does as a company has a significant impact on the price of XRP. The Ripple expert did such a good job of tearing the Securities and Exchange Commission expert to shreds that the Commission expert tried to sneak a late amendment into his report. For the past 3 months, this has been going on behind the scenes. We're only seeing 2 of the battling experts right now. There are 16 according to reports. Always keep in mind that if the experts tie, the defendants win, each and every time. That's for sure, and it's been going on for longer than 3 months. So how will the SEC versus Ripple wrap up after all this? When it comes to the XRP litigation, everyone agrees that a resolution, whether through a settlement or a court judgment, is imminent. An ex-commissioner, Grundfest, explained why he believes it will be a difficult matter for the Securities and Exchange Commission in an interview. While there is a lot of public debate about whether XRP is a security or not, he said, there are other issues here that I think are intellectually even more intriguing and may even be more outcome determinative. Furthermore, according to a U.S. Supreme Court decision, federal securities laws only apply to transactions that take place in the United States, with one rule of thumb being that the transaction must be completed within the jurisdiction. As a result, if you trade XRP on a foreign exchange outside of the U.S., the regulators will be unable to contact you. As a result, the SEC will have to deal with the XRP structure's complexity, consensus process, and decentralized nature to determine whether it falls under their jurisdiction partially or completely. To verify this, the SEC must examine the blockchain history, and if they are unable to determine where this occurred, how will they determine whether XRP is a security? Even if this is determined to be a security, the SEC may be unable to access transactions unless they can prove they occurred in the United States, which they may be unable to do due to the decentralized disposition of the XRP system. If this is correct, the SEC may win the battle but lose the war. So what do you think is going to happen?
So enjoy your day, everybody. I'm always here for you. Leave any comments or questions below, and be sure to subscribe. But thanks, everybody. I really appreciate you. Enjoy your day, and I always have your back. So thanks so much, everybody.